Welcome back, everyone. We're ready to resume hearing from Mr. Taverner when we're back in contact. Yes. Hello, Mr. Taverner.
Thank you very much.
All back in contact?
Thank you very much indeed, if you can hear me, sir.
Yes, we can. Thank you very much. Right, well then, carry on when you're ready, please.
Thank you. Mr. Chairman, I was dealing before the adjournment with particular incidents relied on by some court participants imbuing Rydon with knowledge of the risks of the components. I dealt with the knowledge of Rydon personnel that RB55PE had a polyethylene core and the Chalcott's Taplow House fire reports. I turn now, if I may, to the Lacknell moment. Arconic, paragraph 170 of its Module 2 closing submissions, contends that Rydon's attention was expressly drawn to the issue by the email relating to the Lacknell moment. And they say even this did not suffice to induce them, that's Rydon, to ensure that the regulatory regime was complied with. Again, these criticisms are misplaced. The email referred to is that from Claire Williams, dated the 12th of November 2014, which can be found at RYD 000023468, where she said she just had a Lacknell moment. We turn to this particular topic at paragraph 4.37 and 4.38 of our closing submissions. Mr. Lawrence explained that he did not have the expertise to answer any technical questions raised by Claire Williams, and he probably would have passed it on to Harley. He said that at day 64, page 164 and following. He believes he would have understood the question to relate to the lower 4 floors. It was there that GRC, glass reinforced concrete panels, were being installed and being discussed at the same time. But there's absolutely no reason why Mr. Lawrence would not pass on fire retardancy issues to the specialists. And there's no reason to believe that he would not have relied on them to talk to TMO direct or done anything other than pass on their responses and their views. We know that Harley's view was that it was safe to use RB55PE. Mr. Bailey told the tribunal he considered he was entitled to rely on the BBA certificate stating that RB55PE was class 0 or class 0, and that he assumed that it was that was sufficient to satisfy the approved document B. We refer there to his evidence at day 32, page 25, and day 33, page 37 and 38. Accounts given by Claire Williams and Mr. Gibson as to conversations they had with Mr. Lawrence are difficult, frankly, to believe. I'll say no more than to refer to the analysis and conclusions reached by BSR Team 1 in their Module 1 closing submissions as to the veracity of their accounts, that they set these out at paragraph 3.71, page 15 of those submissions. They too consider them unbelievable. Can I turn now, if I may, to a different topic, and that's whether or not Rydon should have engaged a facade engineer or a fire consultant. I turn first to a facade engineer. Mr. Sekula gave written evidence in his report JOS 60701 and at paragraph 6.51, where he said, and I quote, "By 2012, in my experience, it would have been normal for a facade engineer to be appointed for any large complex project. The overcladding of a high-rise residential tower is a large project, but it may not be complex. The situation in which a facade engineer would not be appointed for this kind of project would be where the architect had enough technical knowledge and relevant experience not to require the additional expertise, or where the building owner did not wish to pay for an additional consultant." In oral evidence, Mr. Sekula said appointment of a facade engineer was not necessary on any large or complex project. He said some architects are comfortable with their technical knowledge and feel that they don't need the services of a facade engineer. Others welcome it and would rather have a facade engineer on board. GT was not a complex project from a facade point of view, although it was large. We refer there to his evidence on day 125 at paragraphs 127 to 128. Going back to his report, he said, in the case of Grenfell Tower refurbishment, I would expect such an appointment to have been considered by the tenant management organisation in dialogue with Studio E during the pre-novation phase. The dialogue would have had to need to address whether Studio E had the required experience and or technical expertise in overcladding a tall residential building. Mr. Sakula said in oral evidence that the party that should have initiated the discussion about whether a facade engineer should be appointed was Studio E, not TMO. He said if Studio E had doubts about their capability to design the facade, they needed to consult or consider appointing a facade engineer. Again, that's at day 125, pages 129 to 132. Mr. Sakula agreed that it was his view that in the absence of the appointment of a facade engineer, the reasonably competent cladding contractor could be relied on to have such design and technical expertise in-house. That's the same transcript, day 125, at pages 140 to 141. The sum of all of this is that it was not necessary to appoint a facade engineer on this project. Neither Studio E or Harley expressed the need for a facade engineer or in any way indicated that their knowledge and skills required the appointment of such a professional. And certainly there's no suggestion in the circumstances of this case, nor was it put to any of the Rydon witnesses, that it was in any way blameworthy for them not to have considered engaging the services of a facade engineer. Turning now to fire consultancy, we turn to the appointment of Exova by TMO and the charge against Rydon that it ought to have engaged a fire consultant or ensured that Exova had completed the tasks promised to complete under its engagement by TMO in some detail in section 14 of our written closing submissions. It's at page 72 of those written closing submissions. On day 65, pages 148 to 151, Mr. Hyatt, the architectural expert, was asked by counsel for the inquiry whether an architect novated to the design and build contractor should insist on the appointment of a specialist fire safety consultant on a project such as this. Mr. Hyatt said in response that some architects would be very much more comfortable doing a building like this because they had done many of them. If they felt comfortable, no. But you asked me early on, should an architect assess their own abilities? I think this architect should have considered its own experience and abilities. In the end of the passage of questions asked by counsel, he said that Studio A should have given the strongest recommendation, the appointment of a fire consultant. Similarly, if Harley considered themselves not sufficiently skilled to ensure that their specialist cladding work was safe and complied with the building regulations, then again, it was for them to say so and recommend consultation with a fire consultant. As stated by BSR Team 2 at paragraph 7.35 of their submissions, and they're citing Mr. Hyatt, Studio E should have made it very clear to Rydon that there was a need for a specialist consultant to be appointed in the absence of Exova. It was said yesterday by counsel for Exova, and the reference is day 174, pages 7 to 8, that there were 6 attempts to persuade Rydon to use a fire consultant. He went on to say at page 56 of the transcript that Rydon were advised on several occasions by others in the design team to instruct a fire consultant. No source reference was given by counsel for Exova, and it's simply wrong. Mr. Blake said that Rydon did not appoint a fire safety engineer because that is the remit of an architect. And he said, this is transcript 29, page 64, Studio E did not advise Rydon that a fire safety engineer was required. Mr. Crawford said, he's Studio E, that he knew we had recommended repeatedly that fire consultants be used at the start of the project and believe Bruce recommended they were used in the post-novation stage. He also said he had no reason to believe they weren't appointed by TMO or another entity since Exova responded to queries. He said it wouldn't have dawned on him to explore with TMO or Exova what the terms of that's Exova's appointment were. He said he knew Studio E had not appointed Exover, but his understanding was that they were available to Studio E as a resource they could use on an as and when basis. And that's day 10, page 31 to 33. Mr. Crawford said he does not recall impressing on Mr. Lawrence that Exover hadn't provided the promised analysis. That's at day 10, page 36. Later on in his evidence, Mr. Crawford said that he saw the consultation with Exover as ongoing. As the details of the cladding became more apparent, he sent them to Exover. It would only have been a problem for Mr. Crawford and Studio E if Exover had said that they couldn't respond as they weren't appointed, but that wasn't the case. He says that if he asked for advice and it was given, then he had every reason to believe that he was getting all the advice that was required and wouldn't question the scope of the advice. That's at day 10, pages 38 to 40. Seems that Mr. Crawford considered that because Exover provided advice, he didn't question the arrangements, essentially saying he never needed to recommend appointing them. Now, Mr. Soon said that Studio E had conversations with TMO and recommended further fire advice was required. He said that that detail would have included the cladding. It would have been the detail of everything. That's day 12, page 159. Soon understood that Rydon wasn't going to be instructing Exover or another fire consultant. And that was what they normally did. That's at day 12, page 167. Soon says he remembers discussing Mr. Lawrence's approach with him. He doesn't remember having concerns at the time. He thinks he queried this once, but doesn't remember pressing him on it, adding that he would have pressed him had he believed at the time Exover or another fire consultant should be appointed. Importantly, he said he did not think it was important to tell Mr. Lawrence that a fire safety consultant needed to be retained to deliver that analysis, because it was for the specialist to follow through with that analysis. It's at transcript 12, page 168, 169. He says he remembers querying about fire advice, but doesn't think he put it to anyone in writing and couldn't say why he didn't repeat the advice to Rydon and the TMO post-novation that further advice was needed. It's at pages 172, 173 on day 12. Turning to Harley, Mr. Ray Bailey said that the product was specified by Studio E, Exover were their fire consultant. So by the time the design was passed down to us, the prescriptive design were named Celotex. And then he said we were doing our own backup to check to stuff that had already been signed off by them. That's at day 33, page 28 and 29. Mr. Daniel Anketel-Jones said he would have assumed that establishing a fire strategy for the cladding design would have been done at RIBA stage 4 by the architect. He does not agree with Bruce Soon's evidence that it was Harley's responsibility to do so. Transcript 36, pages 206 and 207. Kevin Lamb said he did not give a vast amount of thought to which route to compliance was being followed, but he knew that the architect was backed up with a fire engineer. We followed the architect's advice. That's at transcript 38, page 48 and 49. Mr. Lawrence's evidence that he considered engaging a fire consultant for certain aspects of the project, the lower 4 floors. In the light of the professional team he had around him, he did not. It was not put to him that he was advised, instructed, or sought to be persuaded by anyone to engage Exover. The fact is at no stage was any such recommendation by Rydon, by either Studio E or Harley, the appointment of a cladding consultant or a fire consultant, either in strong or indeed any terms. Rydon was not privy to any discussions that Studio may have had with TMO or Artilia pre-Rydon's involvement. Perhaps the real point is this: if, as Mr. Hyatt and Mr. Sakula suggest, as they do, that Studio E and Harley, as architect and specialist, ought to have had the skills to ensure compliance, Rydon cannot be blamed for assuming the same, and they were not alerted by either to the fact that they did not. Of course, overlying all of this is the fact that Exover did not point out that its reports were incomplete and therefore unreliable. That, notwithstanding, its contract was continuing. Now, again, I turn, if I may, to an entirely different topic, and that's procurement. Many parties point to the procurement process and potential failings in that process. Rydon set out its position in some detail at section 17 of its closing submissions, page 90. But we'd like to add this. The inquiry is aware that the governing procurement regulations are the Public Contract Regulations 2006. They apply to procurements commenced before the 26th of February 2015. The regulations are addressed to the contracting authority, that is, TMO, rather than placing or extending such obligations onto bidders such as Rydon. Regulation 47 states that the duties are owed by the contracting authority to economic operators, i.e. bidders, and that breaches of such duties are actionable by economic operators. Trow & Hamlin's advice to TMO in early March 2014, which was quoted in full by counsel to the inquiry during Mr. David Gibson's oral evidence, that's at transcript 55, pages 43 to 44, stated that the restricted procedure does not permit the contracting authority to undertake negotiations with the tenderers prior to contract award, and does not provide for the contracting authority to revise the tender documents or for tenderers to submit revised best and final offers. To do so would be a breach of the EU regulations, even if you allowed all the tenderers to renegotiate their prices. This advice was then quoted by TMO's Jenny Jackson in her 2nd of March 2014 email to Artilia and others at TMO. It was seemingly sidelined with the proposal that, and I quote, there will need to be some informal discussion with the preferred contractor prior to award so there is an understanding of the approach. That's at ART 406433. Rydon understands that from Mr. Madison's evidence, this is T59, page 18, that TMO sought further advice from Trow & Hamlin's around the 18th of March 2014 regarding the risks involved in having discussions with Rydon, but not with the other bidders. Trow & Hamlin's advised that there was a risk, albeit small, that TMO would be challenged. Rydon was not privy to advice given by Trow & Hamlin, nor internal discussions with TMO and between TMO and Artilia about that advice and its interpretation. The onus was on TMO to comply with the rules. It was TMO who were vulnerable to a procurement challenge in the case of breach of the regulations. Rydon doesn't go into whether or not there was a breach of the regulations, but if, as has been suggested by other court participants, there was a breach, then this is surely a matter for TMO and not something which could be used to criticise Rydon. This particularly so in circumstances where Rydon was not privy to any advice which was given. Now, another topic which has been raised is but by the written submissions and also in oral submissions relates to the prices paid by Rydon for cladding materials. Now, we set out our position at section 18, page 93 of our closing submissions. And all of the references are set out there. As indicated above, Rydon was invited in 2014, March 2014, to identify the amount by which it would reduce its price if different identified products were used. These products included RB55PE cassette and RB55PE riveted or face fixed. The savings offered by Rydon if PE cassette was selected was 293,000 odd, and the saving for using face fix was more than 376,000. TMO chose PE cassette and a saving of 293,000. Now, this was a commercial transaction between two contracting parties. There is massive criticism that the price reduction Rydon proffered was less than its cost saving. And Rydon maintains there was nothing wrong with this. There was no duty to pass on any saving it agreed with its subcontractor, either on a pound-for-pound basis or at all. On Monday morning last, day 173, pages 15 and 16, Rydon heard a suggestion, not presaged in any written closing submissions, that Rydon was under a duty owed to TMO not to make a secret profit. Reference was made to a 12.5% profit figure, which counsel for BRS Team 1 suggested, and I quote, Rydon had declared a profit margin. It was said again, and I quote, by secretly pocketing additional savings, Rydon increased its profit margin over that declared. Had TMO known, Rydon would not have been awarded the contract on those terms. It had declared in the tender. Frankly, we're not sure we understand this or on what basis it is being said. Doing the best we can since Monday, the only document we have found, which refers to a 12.5% figure, is Rydon, it's in Rydon's tender at B12 of the contract sum analysis, at part 5 of the contract package, which refers to contractors' OHP 12.5% included. So, and that can be found at TMO 0100417191_0263. And I quote again, contractors' OHP 12.5% included, quotation mark end. Included means included in the overall contract tender. OHP stands for overhead and profit, not just profit. Rydon refutes that it was obliged to disclose or disgorge to TMO any profit it anticipated making or did in fact make over 12.5%, whether net or gross of an anticipated or actual contribution to an overhead figure. And this is so whether the 12.5% OHP is said to relate only to just a particular external cladding product, RB55, the cladding system as a whole, or the contract as a whole, and whether the tally as to whether the overhead and profit was exceeded or not is to be taken at the beginning of the contract or at the end. In this regard, the inquiries also referred to the fact that at November 2016, Rydon anticipated its margin to be 5.15%. And again, see in that regard RYD 000092301, which formed part of Rydon's management accounts. That 5.15% included the adjusted value of the cladding. Now, that the sums actually received remedied to a certain extent a pricing error which had made is used as an additional criticism of Rydon, and it should not be. Because of the commercial relationship between it and TMO, Rydon was able to maintain a contribution to overhead and profit it otherwise would have lost. It was not, therefore, even profiteering when the transaction is looked at as a whole. It should also be borne in mind that even if Rydon had simply charged cost, TMO cannot reasonably suggest it would not have selected RB55PE cassette. It's notable that TMO chose cassette, a more expensive option than the face fixed. Finally, and perhaps the most important point of all on this topic, any suspected was unsafe product or an unsafer product than other products being considered to make up a loss has no foundation in the evidence and would be wholly wrong. Building control. Just a few things about building control. Rydon accepts that building control was not part of the design team. The design team, headed up by Studio E, was made up of those engaged by Rydon to design. Building control, however, did accept the cladding system as being compliant. And it would be wrong, it submitted, to ignore the effect that building control's certification of conformity would have had on a design and build contractor such as Rydon. Any reasonable design and build contractor would, at the very least, have taken this as reinforcing its views that what it had done was compliant and safe. Plainly, certification by building control would not have given any cause for Rydon to question the competence of its professional team. Finally, I'll deal very briefly with some points raised by Siderise this morning. Rydon have taken great care in ensuring that submissions are completely accurate. Siderise had not notified us, or indeed anyone, as far as we're aware, that they consider them to be factually inaccurate before this morning, and we've not had an opportunity to review it. Notably, however, Siderise did not deal this morning fully and head-on with the inadequacy of Mr. Mort's advice given to Harley in March 2015. Mr. Mort knew that Grenfell was to use ACM, and he knew his product would be of little effect when used with the ACM used at Grenfell Tower. In this regard, we refer to our submissions at paragraphs 8.15 to 8.17 of its closing submissions. We should just add that there may also be relevant and associated issues for Module 6, which we will address further. So can I now come to my overall conclusions? The charge against Rydon must be that it did not act as a reasonable design and build contractor and was therefore in breach of its obligation in relying on others. But it operated within the design and build model. It engaged professionals previously engaged by the client, a well-worn industry standard path. It subcontracted specialist works to Harley, as normal. There's nothing unusual in relying on what Rydon took to be competent professionals to discharge their duties under their respective contracts, and for them to advise Rydon in the event that they consider themselves not able to do this. This is standard practice. Any attack on the competence of any particular Rydon employee for example, not having specialist knowledge of particular products or researching the details of particular projects pays no fair due regard to what the industry would expect of the skills possessed by individuals within such an organisation. There can be no proper suggestion that Rydon should have employed in-house a particular individual with particular skills who would have realised that it was being ill-advised by Studio E or Harley. Rydon, as is the norm, entered into contracts with others by which their obligations were passed down to those whom it not only believed but was entitled to expect were better placed to discharge those obligations than itself. And there's nothing discreditable or disreputable in seeking to do that. Rydon as a company and their personnel might, with the benefit of hindsight, wish it had done things differently. That's not the same, however, as saying that then, in real time, it operated outside the compass of a reasonable design and build contractor. Rydon's conduct can only be fairly considered with due regard, having been had to the context. The inadequacy of the regulatory regime, the exploitation of that fact by manufacturers, the inadequacy of the testing and certification regimes, and the standard practice of design and build contracts engaging specialists to discharge its duties owed to its client. Finally, Rydon and its employees express their genuine regrets and their sympathies to all those countless people who've been and continue to be affected by this tragedy. It's understandable that Rydon's condolences and those of us who represent them may be disregarded as being hollow, even formulaic, by those who have suffered at the hands of work overseen by Rydon. But they are nonetheless genuine and heartfelt. Many thanks for the inquiry's patience.
Well, thank you very much, Mr. Taverner. We're grateful to you for your statement, which contains a lot for us to take into consideration, of course, together with your written statement. The next statement is going to be made by Mr. Williamson, Queen's Counsel, on behalf of Team 2 of the bereaved survivors and residents. And I see you there on the screen, Mr. Williamson. Good afternoon.
Good afternoon, sir.
And I take it from that you can see us and hear me clearly.
Indeed.
Good, thank you. Well, we invited you to come on a little earlier because Mr. Taverner indicated that he probably wouldn't want to run on till 2:45. I hope it's convenient for you to come on at this point.
Indeed.
In that case, we invite you to make your closing statement.
Thank you very much, sir, and thank you for this opportunity. Mr. Chairman, Ms. Estefan and Mr. Akbor, in these submissions, I'm going to be dealing with the Module 1 issues on behalf of Team 2 for about 45 to 50 minutes, and Mr. Stein QC will then be covering the Module 2 topics for a similar length of time. On the first day of Phase 2 of this inquiry, counsel to the inquiry observed that the corporate participants had elected, quotes, to indulge in a merry-go-round of buck passing, close quotes. This process continues. The written and oral closings of the core participants responsible for this tragedy have contributed little to understanding what went wrong. We share the Mayor's disgust expressed this morning at the corporate core participants attempts to evade responsibility. Those are an insult to our clients, adding further injury to the immeasurable pain that has already been caused to them. Indeed, the last 3 days of oral closings have been an unedifying spectacle, and we are glad to be given the opportunity of a last word on behalf of the victims of these corporate parties. Those parties have made no real attempt to answer the question which Mr. Mansfield QC posed almost 4 years ago. How on earth, he said, in the 21st century, in one of the richest boroughs in the United Kingdom, can a block like this just go up in flames with so many casualties involved? The inquiry has now heard many weeks of detailed evidence in seeking to answer that question. In these brief oral closing submissions, I can't do justice to the scope, breadth, and horror of that evidence. I will seek simply to highlight the most egregious failures of the parties most starkly responsible. I begin with Studio E. As a designer and lead consultant for the TMO, Studio E were required to prepare a design that complied with the building regulations. They were obliged to investigate and ensure compliance with statutory standards. They should have produced tender documents which specified only compliant products. After they'd been novated to Rydon, Studio E remained responsible for all the design work undertaken, for the suitability of the specified products, for ensuring that all their designs complied with the statutory requirements, for coordinating and reviewing the designs of subcontractors, including Harley, and for managing building control on Rydon's behalf. They were also to advise on the need for and scope of services by consultants and specialists, including Exova, and to incorporate their input into the design. They failed manifestly to comply with those obligations. Their willful ignorance of the scope of their contractual responsibility, of the relevant building regulations, and of the improved guidance led to the production of a non-compliant and dangerous cladding design. They failed to carry out any early evaluation of the regulations or the approved documents, and that meant that they did not appreciate the risks posed by the ACM panels and the Celotex insulation. Despite the obvious dangers, they failed to take the necessary steps to ensure that Exova were properly engaged. Most significantly, they relied upon the supposed expertise of others, especially Harley. For example, in September 2013, Studio E told Artelia and the TMO that they had, quotes, met with Harley this morning to discuss the project. Their recurring experience is that budgets force clients to adopt the cheapest cladding option, ACM face fix. Now, Studio E carried out no due diligence on Harley, but relied upon them to propose safe materials for the cladding system. That reliance was completely misplaced. But what is so striking and so chilling is that Studio E never asked themselves the question, are these materials safe? Likewise, Studio E never devised a fire strategy for the cladding and never ensured that Exova developed a suitable fire strategy. From first to last, the documents which Exova produced simply stated, as to Regulation B4, that it was considered that the proposed changes would have no adverse effect on the building in relation to external fire spread, but that this would be confirmed by a future analysis. In fact, there never was such an analysis, and Studio E never pursued this. On the contrary, Studio E took a casual, evasive attitude to fire safety. For example, in April 2014, Claire Williams told Soons that they had had a meeting with the fire brigade and that she wanted to get the TMO's fire strategy onto their radar. Soons replied, attached is the fire strategy and RBKC's markup of our fire strategy plan. I wouldn't show this to the LFB. They're likely to support the severe interpretation of the regulations which Exova believe are unnecessary because this is an existing building. In fact, a, quote, severe interpretation, close quotes, of the regulations, or even any interpretation at all, was exactly what was required. But such an interpretation was singularly lacking from Studio E. What they in fact did in the middle of 2014 was to pass conduct of this project to Neil Crawford, who was not even a qualified architect. He thought, wrongly, that his role was limited to reviewing the designs to ensure compliance with architectural intent only. But of course, Studio E's obligations were far more wide-ranging than that. Crawford took no effective steps to ensure that Exova were properly engaged with the project. This was even though, as I have said, no analysis had been carried out of compliance with Regulation B4. Later in 2014, there were discussions about cavity barriers. Crawford, who clearly did not understand the requirements of the building regulations, simply acted as a postbox between Harley and Exova. For example, when Crawford sent Exova's Fire Strategy 3 to Building Control in September 2014, he did not highlight the fact that Exova had not updated its analysis of external fire spread. He wrongly concluded that it, quotes, was not a risk. In their closing submissions, Studio E don't seek to explain these or their many other failings, but instead they make three main points. The first is to make an ad hominem attack upon Mr. Hyatt, the inquiry's architectural expert. This is completely unjustified. Mr. Hyatt's evidence was clear and compelling. He established beyond doubt that Studio E's repeatedly fell below the standard of the reasonably competent architect. Its failures are not excused, as he explained, by complexities in the regulatory system or their inability to understand their own contractual obligations. Secondly, Studio E accused counsel to the inquiry of unfairness in his questioning of Studio E witnesses. There is no warrant for this criticism. If Studio E had wished to make such points, the time to do so was while the evidence was being heard, not in closing submissions. Finally, Studio E in effect say that they were no worse than many other architects practicing at the time, in that ACM was widely specified and used on high-rise buildings. This suggestion lies in the mouth of Studio E, given that Crawford told Exova in March 2015 that, quotes, metal cladding always burns and falls off, hence fire stopping is usually just to the back of the cladding line. Studio E, therefore, have offered no real defence for their actions and omissions. Those actions and omissions contributed substantially to this tragedy. Turning now to Rydon, the circumstances of Rydon's appointment were highly unsatisfactory, even fraudulent. Illegitimate post-tender negotiations took place between Rydon and the TMO. Rydon exploited their private access to the top decision makers at the TMO in order to secure the contract. They were told they would be appointed subject to value engineering with a target of about £800,000, including cladding savings already priced. Their lowest bid was then accepted without question, leading to the purchase of the cheapest but most dangerous of materials. Rydon were, in fact, under their contract, fully responsible for the design of the whole of the refurbishment and required to satisfy themselves that the designs prepared by Studio E and Harley were compliant. They were also required to carry out in the design and construction works in accordance with good building practice and in compliance with the contract documents and other statutory requirements. They warranted that they would not, quote, specify, authorise, cause, or allow to be used in the refurbishment any deleterious or non-compliant materials. However, listening to Rydon's evidence and submissions just now, one might be forgiven for thinking that this was a company with no responsibility for anything, let alone for the safe design and construction of the refurbishment works. Indeed, Rydon assert in their closing submissions that, quotes, Rydon's role was only to provide construction management. Rydon delegated to Studio E the responsibility to manage compliance with the employer's requirements, the relevant regulations, and coordinate design works. That position, which we've just heard reiterated by Mr. Taverner, is clearly unsustainable, legally, morally, and factually. Rydon's contractual undertaking to the TMO to be responsible for the design and construction of the works required them both to review the designs prepared by Studio E and Harley and to ensure that the works and the design were free from defects. In managing the project, Rydon's failings were manifest. Indeed, standing back, the position of Rydon is obviously and overwhelmingly untenable. 72 people died in a terrible fire shortly after these works were completed. How could Rydon, who accepted full responsibility for all aspects of the design and all aspects of the construction, ever evade responsibility for that? Rydon ought to have set up an appropriate structure to ensure that all aspects of the design and construction works were adequately addressed. However, no such matrix of responsibilities was ever established, and so they failed to ensure that those involved in the refurbishment understood and undertook their responsibilities. Rydon ought also to have taken steps to satisfy themselves that Studio E were competently resourced to carry out design work on the project. Instead, they simply assumed this without undertaking any due diligence. Rydon were also not competent to check the works of Studio E or Harley or Osborne Berry, as their employees lacked even a basic understanding of the building regulations. This was truly a case of donkeys led by donkeys. However, Rydon's sins were not ones merely of omission. They played a central role in the selection of non-compliant materials for the tower, including in particular Arconic's Rainabond ACM panels. Rydon also failed to notify that the specified rock pool for the voids around the window frames had been substituted by SD plastering with the highly combustible Celotex TB4000 and Kingspan Thermopitch TP10 insulation. Rydon claimed in their opening submissions that as discussions about the choice of cladding panels progressed, their stance remained, quotes, neutral. The evidence shows to the contrary. In May 2014, Rydon put forward their, quotes, case that ACM is not an inferior product to zinc, close quotes, and Simon Lawrence accepted in evidence that Rydon saw themselves as an, quotes, advocate for ACM against a reluctant planning body, close quotes. Despite Rydon's proactive role in the change to ACM, they did nothing to check that the panels were suitable for use in buildings above 18 metres. They didn't ask Studio E about the fire performance of the panels, and it did not occur to them to ask Exova to confirm their suitability by reference to Regulation B4. When asked why Rydon did not scrutinise Exova's work or instruct another fire engineer, Lawrence's evidence simply was, I can't explain. Another glaring example of Rydon's failings is that in September 2014, they were copied into email correspondence between Harley and others concerning cavity barriers. This should have alerted them to the fact that these supposed specialists, Harley, Studio E and Exova, did not understand the requirements of the building regulations. Rydon simply left such matters to be resolved by Studio E and building control. Indeed, Rydon wrongly regarded and treated building control as if it were part of the subcontractor team, as if it were an adequate substitute for a fire safety engineer. It was not. In that same month, September 2014, another opportunity arose for Rydon to ensure that Exova properly addressed fire safety. Instead, Lawrence simply emailed Crawford to say, quotes, I'm just catching up on emails, particularly around design, and I have noticed Exova in the chain. I know that they provided information in the tender for the TMO, but I don't know if they're still working for them. I know that we haven't employed them, so if you're getting some free advice, then great. Otherwise, we will need to look at this. Lawrence did not consider it important to understand the basis on which Exova might have been willing to provide free advice or to integrate Exova into the design team, even though Studio E and the TMO were led to believe that Rydon would be appointing a fire safety engineer. Lawrence recognised in evidence that such an appointment was, quotes, essential. In Exova's absence, the truth was that no one was advising on the fire safety implications of changes to the design post-tender. In November 2014, as we have heard from a number of parties, Williams of the TMO eventually had her so-called lacnal moment and sought clarification from Lawrence on the fire retardants of the new cladding. Rydon didn't respond and cannot explain this failure. By April 2015, Rydon had Harley's designs and knew that the Celotex RS 5000 insulation was to be incorporated into the cladding system. However, no one at Rydon thought to check if Harley or Studio E had considered whether the components of the cladding system were comparable to the tested system identified in the RS 5000 datasheet. Nor did Rydon contact Celotex to discuss the suitability of RS 5000 for the tower. Indeed, Rydon's pious assertion in their written closing submissions that, quotes, "It cannot, however, be blamed for the dishonest behaviour of Arconic, Celotex and Kingspan, the use of their unsafe and dangerous products at Grenfell was not only the foreseeable, but the intended consequence of their commercial objectives," close quotes, would carry rather more weight if they had taken any steps at all to investigate the safety of the products which they were using. I turn now to Harley. Harley and the individuals from the company who gave evidence sought to pass on responsibility to others and assumed that matters would be all right without checking. These were characteristics of this project and characteristic failings of this project. It was Harley who promoted the use of the ACM panels. It was Harley who received the BBA certificate for the Rainabon panels from Arconic and say that they took comfort in the Class 0 classification. However, they failed to appreciate that the panels, which contained a PE core, could not be compliant with approved document B simply because the surface was said to be Class 0. In fact, Harley were aware at the time that the ACM was highly flammable. In March 2015, there was a discussion about fire stopping between Harley, Rydon and Studio E. Anketel Jones of Harley observed, quotes, "It's ridiculous. There's no point in fire stopping. As we all know, the ACM will be gone rather quickly in a fire." Harley were responsible for ensuring that the design of the facade complied with the relevant statutory requirements and for checking whether the materials specified by Studio E were compliant. Yet each Harley witness asserts that someone else was to perform this responsibility. This failure to check extended to the RS 5000 insulation, which Harley included in their designs without discussing its suitability for the tower with Celotex. Lacking in-house expertise and resource, Harley subcontracted the design work for the cladding system to Kevin Lamb. He had no specific training in fire safety within facade design, had never worked on a high-rise residential overcladding project involving ACM, and had little experience of cavity barriers in cladding systems. Harley took no steps to ensure Lamb was competent to produce compliant designs. Lamb then prepared designs based on the Studio E NBS specification. His evidence is that he did not consider and was not told that his role extended to ensuring his designs complied with the building regulations. He wrongly assumed this would be carried out by Anketel Jones and Ray Bailey of Harley and by Studio E. Anketel Jones, in contrast, claims he thought Lamb and Ben Bailey would do so, while Ben Bailey considered the role would be performed by Anketel Jones. The cavity barrier issue came up again in the early part of 2015 when there were discussions as to the requirements between Harley, Studio E, Rydon and Building Control. Ray Bailey admits he was surprised that there appeared to be a significant level of confusion between the design team, but that he did nothing to satisfy himself as to the requirements of ADB. He also now accepts that Harley's drawings, which omitted cavity barriers from around the windows, were erroneous. Those designs also omitted cavity barriers from the top of the columns, a failure which ultimately led to the fire to spread to the crown. The need for cavity barriers at the top of the columns was never even considered by Ankettell-Jones, and Lamb thought them unnecessary. It is striking and regrettable that Harley have put no closing submissions before the inquiry. Their position is indefensible and they have not sought to defend it. Mr. Lamb has served closing submissions, but these largely adopt the refrain that, quotes, it was not for Kevin Lamb as a subcontractor to Harley to ensure a compliance review process for the whole refurbishment. In fact, those responsibilities fell upon everyone involved. No one could properly seek to pass responsibility on to others on the basis of unjustified assumptions. The responsibilities fell on everyone and were performed by no one. I turn next to Exova, the fire safety consultants engaged in relation to this project. Dr. Lane's opinion of Exova's work is extremely damning. In their closing submissions, Exova seek to criticise Dr. Lane, in particular arguing that she does not consider the factual context in which Exova's work was carried out. This criticism, like that of Studio E of Mr. Hyatt, is entirely unwarranted. Exova simply never delivered the service they contracted to provide. Firstly, Exova were to produce an existing building fire safety strategy. This document should have established a clear baseline for the fire safety at the tower, intended to, quotes, inform the fire risk assessment and fire risk management plan for the building. Instead, in Dr. Lane's words, it was, quotes, wholly inadequate for any relevant purpose to which it was supposed to be put, close quotes, and could not be relied upon by the TMO, quotes, when considering defect mitigation as part of preparing the refurbishment fire safety requirements. Ms. Cooney, who prepared the report, did not even visit the tower. Her report is full of assumptions and unknowns which were never addressed because lack of coordination within Exova meant that a final version of the existing building fire safety strategy was never produced. Mr. Ashton then became involved because in August 2012, Studio E urgently needed a fire safety report for the refurbishment works. He prepared an initial design note, also without the benefit of a site visit, which did not address the functional requirements of Regulation B4. In October 2012, Ashton produced Outline Fire Safety Strategy 1 for the refurbishment works. Again, Dr. Lane is highly and rightly critical. Exova did not produce or provide a set of fire safety strategy drawings. In her view, this fell below the standards of a reasonably competent fire safety engineer. Crucially, Fire Safety Strategy 1 included the statement repeated in the later versions of the strategy that, quotes, it is considered that the proposed changes will have no adverse effect on the building in relation to external fire spread, but this will be confirmed by an analysis in a future issue of this report. This statement did flag up the need for the issue to be revisited, but the use of the words will be confirmed suggests that the view expressed as to the effect of the proposed overcladding was a firm one. In Dr. Lane's opinion, stating that the overcladding would have no adverse effect was, quotes, very serious evidence of professional negligence, and we agree. Nearly a year later, Ashton produced Fire Safety Strategy 2, and 2 weeks after that, Strategy 3. Neither of these reports was materially different from Strategy 1. Dr. Lane considers that Exover's failure to fully address functional requirements B1, B2, B3 and B5, and to entirely omit B4 of the building regulations is evidence of serious incompetence. Again, we agree. Ashton's failure to obtain up-to-date information on the stage of the then stages of the design fell short of what could be expected of a reasonably competent fire safety engineer. Following Rydon's appointment, Exover was not novated. However, Ashton continued to provide ad hoc advice in response to queries from the design team. For example, in September 2014, there were emails exchanges in which Ashton's advice was sought as to the cavity barriers. He failed to look at the drawings in any detail, and therefore did not consider whether there should have been specified cavity barriers around the windows. But although he was sent the datasheet for Celotex RS5000 as an attachment, he failed to open it. This was a crucial missed opportunity. In evidence, he accepted that having chosen to respond to the query, his professional duty was engaged and unchanged, and that he could have easily alerted the design team to the need for the insulation either to be of limited combustibility or justified by test data. I should finally make this point about both Studio E and Exover, both of whom wax indignant in their closing submissions about the alleged unfairness of the expert evidence of Mr. Hyatt and Dr. Lane. The short answer to these complaints is that had they wished to raise such matters, they should have applied to the chairman for permission to ask questions of a witness giving oral evidence relating to them pursuant to Rule 10 of the inquiry rules. They did not make such an application, and they cannot now, we say, complain, having failed to do so. I pass now to the Royal Borough of Kensington Chelsea, RBKC. Despite all the failings which I have identified on the part of those carrying out the works, it is the case that had RBKC performed its building control functions competently, this tragedy would not have occurred. RBKC has admitted wide-ranging failings in carrying out building control for the refurbishment. Although its acceptance of responsibility contrasts starkly and favourably with the stance of other core participants, it cannot, in truth, take any credit for this. Faced with the inquiry's findings in Phase 1 that the cladding system failed to comply with Regulation B4, and faced with the overwhelming condemnation of building control in Ms. Menzies' report, RBKC had no choice but to shoulder some blame. In its submissions, RBKC have sought to rely on the fact that many other building control departments also failed in their obligations, given the widespread use of ACM in the UK and indeed elsewhere. Of itself, this cannot exonerate RBKC, nor is it a sustainable position considering the sheer scale of RBKC's incompetence. They failed at every stage of the building control process, from the full plans application, which ought to have been rejected outright, through to the completion certificate, which should never have been issued. Crucially, Ms. Menzies has identified what she describes as fundamental failings on building control's part in neglecting to ask for detailed information on the cladding system and failing to notice the omission of cavity barriers around the windows. Indeed, It was not until the works had started that Mr. Hoban, the principal officer assigned to the project, discovered that ACM was being used. Although he looked at the BBA certificate for the Rainabond ACM panels, he completely failed to appreciate what it said. When he discovered that ACM was being used, he was not concerned, as he trusted Studio E and thought that Exova was still involved. Similarly, he relied on Harley's assurances that the same cladding system had been used before. Likewise, even though he knew Celotex RS5000 was not of limited combustibility, he never obtained justification from Studio E or Rydon's for its use because he, quotes, had a good working relationship with them. Mr. Hoban did not investigate what materials were being used for the window infill panels at all. They were in fact aluglaze with a styrofoam core rated Euroclass Class E, i.e. providing a major contribution to fire. Hoban's approach to the cavity barriers was equally cavalier. Extraordinarily, he says he thought there would be a steel framework supporting the windows, which would act as the cavity barrier around them. In fact, the framework was aluminium, and as he accepted in evidence, there should have been cavity barriers at the head, jamb, and sill of the windows. He wrongly thought that cavity barriers would not be required at the junction between the crown and top of the cladding because it was not a concealed space. Hoban's site visits were also entirely ineffective because he failed to appreciate the need to see each element of the installation of the cladding system. Crucial issues were therefore missed. For example, as the windows had already been installed, he was unable to check whether cavity barriers were installed around them. Building control's failings cannot, however, simply be attributed to the negligence of one officer, notwithstanding the many unjustified assumptions and failure to check, which I have mentioned in relation to Mr. Hoban. The management of RBKC's building control department was wholly inadequate. There was no formal procedure for checking the progress of approval applications. There was no oversight of surveyors' continuing professional development. There was no written plan for the scope and frequency of site visits. There was no adequate system for record keeping. And this ties in with a point which some other core participants, such as the FBU, have made, which is that the underperformance or failure to perform of RBKC's building control department needs to be set in the wider context of austerity. Swinging cuts to the budget of building control had meant a huge reduction in staff. Mr. Hoban's complaints about his workload to his manager, Mr. Allen, were ignored. These complaints give the lie, we would say, to RBKC's claims in their closing submissions that they were concerned only with, quotes, value for money, close quotes, when dealing with the public purse. I turn then to the TMO. Its stance is that it relied upon and was entitled to rely upon the professionals it had engaged. However, this fails to recognise its own responsibility for those appointments and for its mismanagement of the project. The TMO, as we have heard, appointed Studio E not for their own abilities, but to maintain continuity with the Calc project. There was no competitive tender. Indeed, to save time and costs, the TMO avoided the effect of the public procurement regulations by agreeing that they would only pay fees up to the OJEU threshold, with further fees to be paid later. Had the project been tendered, Studio E would not have qualified. Studio E were never asked by the TMO about their experience in overcladding residential high-rise buildings. That experience was non-existent. Likewise, Artelia had advised that Ledbetter should be retained as the main contractor. However, this failed for financial reasons. The TMO budget for the works was unrealistically low, some £4 million below Ledbetter's suggested contract figure. This led to the decision to re-procure and the subsequent appointment of Rydon, whose bid was by far the lowest. This did not ring alarm bells with the TMO, who needed to make yet further savings of about £800,000. They then, in breach of the public contract regulations, negotiated with Rydon to secure an even lower price. Cladding was the key component of the necessary savings, leading inevitably to the use of ACM. The TMO's determination to keep costs to a minimum meant that they failed to make full use of the professional services available. For example, they chose not to engage Artelia as a project manager, instead employing Claire Williams as the so-called designated project manager. In truth, there was no one designated project manager with oversight of the entire project. Williams was only project managing the design element. Despite Studio E's lack of experience in overcladding high-rise buildings, the TMO decided not to appoint a client design advisor, even though the fee would only have been about £30,000. This role was also purportedly performed by the TMO in-house. The TMO's management team had no appreciation of the significance of the existing building fire safety strategy and the outlined fire safety strategies for the refurbishment prepared by Exova, which I've referred to. And of course, Exova were not then novated. Progress meetings attended by Gibson and Williams of the TMO repeatedly noted that Lawrence was to appoint a fire safety consultant, but the TMO never checked that this had been done. And then, following a change to the CDM regulations, Artelia were no longer required to compile the health and safety file. Williams then, despite having no previous experience of preparing such a file, rejected Artelia's offer to act as CDM advisor and took responsibility for it herself. Significant deficiencies in the information provided by Rydon were missed, and no one at the TMO considered that, as Rydon's information only related to the refurbishment works, the health and safety file also needed to cover other aspects of the tower. Finally, I should say this, that we are seriously concerned about the credibility of the TMO witnesses, given the failure of both Mr. Madison and Ms. Williams to disclose personal diaries and notebooks, and the TMO's lack of candour in failing to address the unlawful contact with Rydon during the procurement process. These matters as to credibility are of particular significance when assessing the evidence which Williams and Gibson of the TMO have given about the assurances they say they were given by Lawrence that the cladding materials were not flammable. Now, I have sought in these brief oral submissions to highlight the parties mainly responsible for the fire. Many other parties who have been referenced in Module 1, to whom I do not have time to refer, also bear their share of responsibility. The truth is that many individuals and many organisations have blundered, and as a result, the residents of the tower were led unwittingly into the valley of death. However, these parties did not set out with malice aforethought to kill 72 people. What is even more shocking than their incompetence is that the refurbishment was in many respects not unusual in the way that it was procured, designed, managed and constructed. The obsession with cost, the fragmentation of responsibility and the lack of clarity over key design decisions are typical of many projects in the UK construction industry. For example, Lawrence of Rydon asserted in his evidence that there were numerous, quotes, layers of quality control and checking, close quotes, but in fact, there was no quality, no control, and no responsibility. This speaks to a deep-seated cultural problem in the construction industry. The inquiry needs to engage on these issues constructively and openly with the bereaved survivors and residents and the wider public. Indeed, this morning, Mr. Taverner asserted that, quotes, Rydon, in delegating responsibility, was operating in an orthodox manner and following standard industry practice, close quotes. If that is right, this shows very clearly how that orthodoxy and practice need to change if future disasters are to be avoided. I turn now and finally to the recommendations which we urge the inquiry to adopt. In so doing, we would ask also the inquiry to consider carefully how its recommendations will relate to the changes set out in the current Building Safety Bill. Firstly, it is apparent that no single person or body was in fact taking responsibility for fire safety on this project. There were times when the TMO and Exala turned their attention to fire safety, but no one ever focused on the issue properly. In future, we say there should be a single, suitably qualified individual who is required at every stage of the project to consider and be accountable for all fire safety issues. Secondly, there needs to be a change from the current practice whereby everybody and nobody is responsible for design decisions. In this case, Rydon, Harley, Studio E and others all had design responsibility, but as the evidence makes clear, their concern was simply to pass that responsibility on to someone else. One way of addressing this would be to appoint an independent certifier for projects like this, wholly separate from the design team, who would impartially provide specialist advice, monitor compliance with design, specification and statutory standards, and ensure all project requirements were met. Thirdly, the key stakeholders in public sector projects, the tenants and the lessees, should be placed at the centre of the process at each stage. After all, these are their homes and their lives. Indeed, on the very day the fire occurred, the Leaseholders Association pointed out that, quotes, the material of the cladding used by Rydon did not meet health and safety requirements in the true sense, i.e. is a fire risk as it is combustible, close quotes. If they had been consulted earlier and more fully, this tragedy might have been avoided. Fourthly, the whole process of building control should be deprivatised and made once more the monopoly of the state. Competition and commercial advantage should play no part in this process. The sole concern of properly funded local authority building control bodies should be the safety of those who live within their areas. This inquiry therefore needs to be prompt, imaginative and proactive in proposing massive cultural change. 4 years have now passed since the fire. There has been no real change in the construction industry. Given the scale of this disaster and the widespread shortcomings which it has revealed, government and the construction industry will surely feel compelled to accept whatever recommendations the inquiry sees fit to make. This is an opportunity which must not be lost. So that concludes Team 2's closing remarks on the Module 1 issue. So I would now propose to hand over to Sam Stein, QC, perhaps after the short break, to deal with the Module 2 issues.
Yes, well, thank you very much, Mr. Williamson. That's certainly very helpful. I think we will take the afternoon break at this point. Mr. Steen was scheduled to speak at 3:45, but I suspect that he may be able to address us a bit sooner than that. So we'll resume at 3:30 and hope to hear him then or shortly thereafter. But thank you very much. Thank you. 3:30, please. Welcome back, everyone. We are now going to hear a closing statement from Mr. Sam Steen, Queen's Counsel, on behalf of Team 2 core participants. If that is, Mr. Steen is there and ready to speak to us. Oh, good afternoon, Mr. Steen.
Good afternoon, sir. Good afternoon, Ms. Istefan, and good afternoon, Mr. Akbar.
And I imagine you can see and hear us well as we can see and hear you.
I can indeed, sir, yes.
Good, thank you. Well, now, thank you for being ready to make your statement a bit earlier than you were originally asked to, but since you are there and ready, we should be pleased to hear from you.
Thank you, sir. 10 months ago, in our opening submissions for Module 2, on behalf of the Team 2 Bereaved, Survivors and Residents, we described the manufacturers Arconic, Kingspan and Celotex as crooks and killers. The evidence now having been heard tells us we were right. The manufacturers operated without any regard whatsoever for the lives of those living within walls covered in their combustible materials. Let me start with Arconic. It was with considerable dismay that those we represent listened to the oral submissions made on behalf of Arconic by Mr. Hockman, Queen's Counsel, yesterday. Frankly, Arconic's refusal to accept any responsibility for its conduct confirms why the industry cannot be trusted with involvement in regulating matters relating to safety. In 2004, Arconic failed Euroclass testing with results that were not usable. This was because the test had to be stopped after 850 seconds. Mr. Schmidt, the president of Arconic, accepted in evidence that the 2004 test, which had to be stopped, contained crucial fire safety information. However, he stated that by this he meant the safety and protection of property, not the safety of people. This illogical argument can only be interpreted as an attempt by Arconic to distance fire safety from being a life and death issue. Further, he admitted that it was irrational and irresponsible not to have carried out further tests. This was the same product, cassette Rainabond 55 PE, which fueled and spread the fatal fire at Grenfell Tower 13 years later. Among the many excuses put forward by Mr. Hockman, Queen's Counsel, was the claim that the Arconic panels were cut in an unorthodox way. This is frankly nonsense. The panels were cassette cut. Arconic tested cassette cut panels. They knew the product was being fabricated and that it was going to CEP to be fabricated into cassettes. Furthermore, 1, the product is unusable in unfabricated form, so it is always sold with the intention of it being fabricated. 2, Arconic provided guidelines on how to fabricate the panels, including the cassette form. 3, the certificates relied upon in the context of Grenfell Tower are based upon Euroclass tests carried out on fabricated versions of the panel. 4, Deborah French provided examples of how the cassette panels looked in sales correspondence for Grenfell Tower. Mr. Hockman, in his submissions, relied in part upon the historical widespread use of ACM PE cladding and the fact that it had received regulatory approval in the past in order to try and defend the actions of Arconic. But these points made by Mr. Hockman ignore Arconic's own internal emailing, which recognized the inherent danger posed by ACM PE cladding and its contribution to numerous high-rise fires around the world. It also ignores the fact that ACM PE cladding is considered to be so dangerous that buildings with it installed are now virtually uninsurable, and why billions must be spent in funding the removal and replacement of these panels. Perhaps the most audacious submission made yesterday by Arconic was the claim that ACM PE was capable of being used safely, even in high-rise residential applications. Arconic simply ignores the DCLG tests carried out post-Grenfell, which demonstrated the inherent flammability of ACMPE and the fact that Arconic's product was being sold in a country here with a stay-put policy. Arconic has also made further comments that it is a remarkable feature of the evidence, they say, that hardly any of the witnesses were prepared to acknowledge awareness of the combustible nature of the panel core. However, ignorance of the reality or a willingness to fake ignorance of the risks posed by ACMPE is precisely what Arconic relied on to carry on selling a product that they knew well to be dangerous. Arconic pretended not to know the dangers of ACMPE, all the while acknowledging internally it posed dangers and refused, nevertheless, to take any action because it was anti-commercial. Two further claims made by leading counsel for Arconic were that from early 2014, it took steps to advise customers of issues with Rydon PE, and those involved in the design and construction of Grenfell Tower are to blame for using the product in an unsafe manner. Arconic has made these claims whilst failing to acknowledge that Deborah French admitted in oral evidence that she automatically priced all projects with PE, and in the context of Grenfell did not provide Harley or CEP a choice between the PE and FR core, or even tell them that the product had a PE core. Arconic has also complained at some length in its oral closing submissions about the questioning by counsel to the inquiry of Mr. Schmidt. However, Arconic raised no objection until now, long after the questioning is over, when neither counsel to the inquiry nor the other CPs, particularly the BSRs, have had any opportunity to analyse such objections. It is difficult to escape the conclusion that the reason for not publicly raising these complaints earlier is because they would not survive even the most cursory analysis or scrutiny. If Arconic had genuine complaints about how Mr. Schmidt was treated under examination, then the proper course of action would have been to raise those issues whilst the evidence was being heard, not in closing submissions. Of course, Arconic could have applied to you, sir, for permission to ask questions of a witness giving oral evidence pursuant to Rule 10 of the inquiry rules. They made no such application. Finally, as regards Arconic solely, it is remarkable that Arconic, in its closing oral submissions, seeks to blame the failure of compartmentalisation and the firefighting ability of the London Fire Brigade. This is analogous to an arsonist blaming the fire brigade for not putting out the fire he started earlier. Let me move on to Kingspan. Kingspan took an early lead in their corner of the marketplace in the race to put combustible but thermally efficient insulation onto buildings. To win this dreadful race, you needed to get your and no one else's combustible products onto high-rise buildings. At the end of 2007, Kingspan tested its new product K15 with disastrous results. Mr. Meredith reported the K15 test had developed into a raging inferno, and that the phenolic was burning on its own steam, and the BRE had to extinguish the test early because it was endangering setting fire to the laboratory. Kingspan have gone to some pains to deny that the new technology K15 performed differently to the old technology K15. We reject the basis of those arguments. Those arguments do not link with the evidence that has been disclosed. After the 2007-2008 testing reports, Kingspan decided not to test their actual product. Instead, they opted to test prototype products that would never make it to their customers as the formula was not commercially suitable. Despite Kingspan's claim to the contrary, their attempted manipulation of government, even after the fire, shows an enduring pattern of opportunism and utter lack of remorse. On the eve of the first anniversary of the fire, a series of emails shows Kingspan wanted to persuade the government not to ban the use of all combustible materials on buildings over 18 metres. Bad press and profits were their only concern. There was not a genuine desire to prevent a further tragedy. Kingspan's PR machine advised, the document we're referring to is KIN 000023990. Kingspan's PR machine advised that pushing too hard towards the topic on money could be taken badly. Nevertheless, on the 13th of June 2018, Kingspan's Group Chief Executive responded, "Surely the penny has dropped now for all of us as to where this is headed." He meant the complete ban. Without a serious intervention, and hanging back at this stage is to condone the direction of travel. We suggest the fire at Grenfell clearly had limited impact on Kingspan's corporate conscience. After the fire, Kingspan pushed ahead from every angle to try to keep combustible insulation on exterior walls. The July 2018 G2 Vitricore and Rockwell test appears to have been designed to present the results to bodies such as the Parliamentary Select Committee. This was in an attempt to undermine Euroclass testing as well as their competitor Rockwell. In trying to discredit Mr. Meredith's 2007-2008 test report, Mr. Webb, Queen's Counsel, on behalf of Kingspan, claimed that Ivor Meredith had limited experience of BS 8414 testing and work. This is wrong. Mr. Meredith was their most experienced team member at the time and had been working on preliminary 8414 style tests prior to the 05 test. Further, their failure to acknowledge the relevance of the calorimeter tests carried out by Mr. Meredith as part of the basis for the claim of reduced performance from old to new tech K15 shows their lack of willingness to engage with this issue. Mr. Webb was at pains to claim a high degree of engagement with the inquiry. They state that they have disclosed 23,500 documents, but they failed to mention their repeated late disclosures. Notably, they failed to disclose Mr. Rochfort's diary prior to the witness's evidence and disclosed further documentation during the hearings in March. Even in their rebuttal of points made about the lateness of withdrawal of test letter in October 2020, Kingspan have still failed to clarify why, when the tests in question were removed from their website in 2019, it took them until a month before the opening of Module 2 to send the withdrawal letter to the BRE. I now move to Celotex. They were attempting to catch up in 2014. Project manager Jonathan Roper explained that he and his company were aware of the dangers of their combustible insulation when he said, "Do we take the view that our product realistically shouldn't be used behind most cladding panels because in the event of a fire, it would burn?" Celotex's attitude in their own written closings is that of a student expressing fury towards a teacher for not catching them cheating during the exam. Whilst the BRE do bear a portion of the blame for not catching the fraudulent and pivotal May 2014 BS 8414 test, it was in that test that Celotex used a non-combustible, unlisted layer, and Celotex's Management Action Board, the MAG, was aware of this. It must not be forgotten why Celotex did this. They sought to hide from the NHBC the unlisted non-combustible layer, since NHBC approval was critical to the success of that product. In order to successfully bring the product to market, Celotex also had to get RS 5000 certified. They admitted using Kingspan's exact wording for their LABC certificate. Mr. Roper's admissions in evidence revealed the story of how RS 5000 reached Grenfell Tower. So ask this question, day 72. By failing to ensure, referring to the LABC certificate, that reflected that BR 135 approval is only for the system tested, Celotex ran the risk of misleading customers. Yes, Mr. Roper said. And misleading building control officers? Yes. And that was intentional, deliberate, and dishonest? I believe so, yes, said Mr. Roper. Mr. Orr, Queen's Counsel, attempted to shift the blame from Celotex onto the construction professionals. Celotex were aware of ignorance and confusion in industry and set about cynically exploiting it by waging a campaign of smoke and mirrors. The data sheet sent to Harley described RS5000 as developed specifically as a premium performance PIR solution for use in rain screen cladding systems. This was not true and not new. It was simply the rebranded FR5000 PIR product. 3 times through the document, the wording deliberately set out an impression of wider applicability and suitability for the above 18-metre market, until you reach the penultimate sentences on page 3. Mr. Orr referred to Class O fire performance throughout the product. Both terms are meaningless and utterly irrelevant to insulation use in rain screen cladding, and we invite the panel to conclude that the only logical reason to insert such references was to give an impression of wider applicability. Now, it is clear the credibility of the BS 8414 tests have been seriously put in doubt, but it is clear that had Celotex not cheated their test, RS5000 may never have reached the market and the Grenfell Tower. And despite Mr. Orr's presentation to the contrary, Celotex conducted a campaign to persuade industry that their material was suitable for buildings over 18 metres plus, when they knew it was not. There is no cause for celebration that the building industry's complacency meant that they swallowed whole the headlines broadcast by Celotex. We suggest that the evidence within Module 2 has demonstrated that there is ample documentary material which the police investigation should be analysing for use within the possible prosecution of a number of individuals and companies for a range of serious criminal offences. Overall, these companies were committing wholly dangerous frauds. Mr. Meredith's explanation before the inquiry of what was going on within Kingspan is exactly what was happening within Celotex and Arconic. On day 76, he was asked this question. This was a deliberate and calculated deceit by Kingspan in which you had become embroiled. Yes, that's correct. Kingspan, Celotex, and Arconic saw high-rise buildings as high-rise additional cash just waiting to happen. What these companies were doing and being allowed to do was to wrap buildings housing families in the high-rise and high-tech equivalent of kindling soaked in petrol. It was a lethal combination. A few flaming drops of polyethylene from the ACM were enough to ignite the foam insulation. But the insulation manufacturers also knew the risk that toxic smoke, such as hydrogen cyanide, was released when PIR burns. Celotex knew and understood or could quantify this risk. But the fact remains, toxicity was and still is totally unregulated. The inquiry needs to grasp this issue. Today, below 18 metres, anything goes. Throughout the entirety of Module 2, we are yet to hear any satisfactory answers as to why, with all this foreknowledge, these products were not removed from the market due to the clear danger they pose to life safety. Preservation of profits is not a sufficient reason to risk large-scale fatalities. The evidence has demonstrated that time and time again, Arconic, Celotex, and Kingspan harboured a disregard bordering on contempt for the rules. They lied, manipulated data, hid results, and threatened litigation, all to get their products to market. The evidence from all 3 companies showed no regard was given to the danger their products posed to the public. Nothing was allowed to stand in the way of market share. If there was a bad test, it was ignored, and the next one rigged until the desired result was achieved. If they found data inconvenient, they simply hid it. If inconvenient questions were asked, they ignored them. I now turn to the testers and certifiers. The moral bankruptcy of the manufacturers doesn't stand alone. They had help. Arconic, Kingspan, and Celotex used the BRE, BBA, and LABC to perpetrate their large-scale conspiracies to defraud. These organizations, with varying degrees of consciousness, allowed themselves to be used. At best, they demonstrated such laziness and lack of rigor in their procedures that they were practically inviting the abuse perpetrated by the manufacturers. Perhaps we might not be surprised that corporations put profit before safety, but we suggest the true shock of Module 2 was the behavior exhibited by those safeguarding the built environment. The prioritization of the interests of the corporate clients by the testers and certifiers did nothing other than prevent the execution of what should have been their mission, to protect life. The BRE predicted a fire such as Grenfell in the 2003 version of BR135 standard, but critically failed to utilize this knowledge to protect the public. Perversely, the BRE's actual testing of dangerous combustible materials showed at least a passive indifference to the known existing danger, and at worst demonstrated a willingness to connive in the use of these materials on buildings. Despite the obvious importance we would all expect of ensuring BRE staff are adequately trained and educated, it became clear in the oral and documentary evidence that this was not the case. In fact, Stephen Howard, the Joint Business Group Manager for Passive Fire Testing, had no formal higher education or formal training in fire safety at all. The BRE claim that they were just a victim of Kingspan and Celotex's deception. But it was their own lax attitude to the testing process which opened the door to the manufacturers to bring in and use what they wanted. As we heard in the evidence, it was possible to skip the proper cataloguing of materials used in tests by sending materials directly to the burn hall instead of via the goods-in system. For a supposedly scientific body, the BRE's lack of scrutiny and absence of systems certainly gives the impression that they are anything but scientific and systematic. The BRE attitude was demonstrated by Mr. Clark, who stated on day 95, the reliance very much was on the honesty of the client. We're not there to police necessarily every nth degree of what they're doing there. There's a large element of trust in everything we do. The trust the BRE placed in these clients was naive at best and complicit at worst. Even when defending the BRE, Mr. Howard was unable to separate the BRE from its client base. He said, BRE is a commercial test laboratory. We have a lot of clients who spend a lot of money with BRE. We don't wish to upset any of them. This is not an appropriate attitude for a body carrying out BRE's functions. We repeat, profit is not and never can be a reason to risk safety. Mr. Clark allowed his independence to be compromised by advising clients about how to pass BS 8414. Even if we discount the evidence that suggests that Mr. Clark knew about the additional non-combustible layer added to the rig to ensure that Celotex's insulation passed the test, there was nothing about the testing process that demonstrated an understanding of the word independent or beyond reproach, as the BRE state on their website. The BRE say that they weren't involved in testing systems used on Grenfell Tower. Whilst this may be technically true, the BRE were aware of the abuse by companies to give the impression their products could be used in a wider application. The single example cited by the BRE of challenging such behavior was Kingspan's 2006 flyer, "What is lurking behind your facade?" BRE claim in their submissions that Kingspan removed the flyer. In fact, Kingspan simply reworded their mantra, which now became Kingspan's Cooltherm K15 has been successfully tested to BS 84141, and when assessed in accordance with BR135, it is acceptable for use above 18 meters. This gave the impression that the product could be used in multiple systems. This simply wasn't true. The BRE failed to challenge the new wording. This mantra was repeated over and over and over again in product literature for Kingspan, and then later adopted by Celotex. The BRE has promised reform and promised change. However, even after all of the evidence heard within Module 2, those in control of the BRE still do not get the point. They claim in their written submissions that the test sponsor must still be responsible for accuracy of the built system. In their written submissions, BRE 000421202, page 8, they go on to say this: there are good reasons for the test sponsor being responsible for the accuracy of what is tested by the test laboratory. Going on to say, if the test laboratory were to assemble the system, it would be open to claims that it had assembled it incorrectly. We suggest that the BRE must radically alter its stance and be prepared to put the strictest of controls on goods into the testing laboratory and use trained expert individuals to certify the rig for any test that it conducts. Frankly, this should be a minimum standard. The fact is that the BRE's privatized status means that they are afraid of criticism from clients, which is why we suggest that the government needs to act and bring it back within state ownership. The BBA. The BBA suffered from an even worse lack of expertise than the BRE, and also suffered from the same lack of independence. Despite the obvious need for a fire expert within the BBA, no such expert was present. Quite simply, Arconic and Kingspan ran rings around the BBA. The BBA's Mr. Gregorian accepted Arconic were driving the basis on which the BBA certificate was issued. There was little pushback from Mr. Gregorian, as he was prepared to acquiesce to Arconic's demands, in part because it was cheaper for Arconic not to do further testing, and also this was simpler for the BBA. He also stated it was just BBA policy to certify the panel, not what he considered to be the system, failing entirely to even consider asking the question whether the change in format to the product affected its fire performance. Even when the BBA requested additional test data, Arconic simply ignored the request, with the BBA doing nothing in response. So, words matter, particularly when you're certifying products. Drafters at the BBA, including Mr. Gregorian, seem to have failed to realize this. Blanket wording on the Arconic certificate led Grenfell contractors to accept that Arconic PE cladding was safe to use. And blanket wording on the Kingspan certification led the industry at large to believe that K15 could be used in any 18 meters plus build. It might be expected that companies will push to get wider wording to benefit their market share. It is not expected that the certifier blindly allows this without question. The BBA state in their written closings that it has no extra contractual power to demand data for products assessed. Mr. Alban gave evidence that we were naive and changed the process as it stands at the moment. We submit no evidence, no claim. All claims by manufacturers should be supported by clear evidence. LABC HBC. Unfortunately, the LABC system of certification was also incredibly problematic. Kingspan misdirected the LABC's agent, Mr. Jones, of Herefordshire Building Control, into believing K15 was a product of limited combustibility. Instead of considering which specific tests might apply, in this case BS 476-4 and 11, or indeed looking up a definition, Mr. Jones instead applied his own functional interpretation, explaining that limited combustibility's purpose was to make sure that the insulation product can't contribute to the development of a fire. In a sense, he made up his own rules and applied them. The fact that Mr. Jones still stood by his functional interpretation in his oral evidence makes a worrying statement as to the state of training and monitoring of building control by central government. What has been shown in the evidence is that the claim that RS 5000 was acceptable for use in buildings with stories above 80 metres in height had been copy-pasted by Mr. Roper directly from Kingspan's March 2011 datasheet to the LABC, and they simply lifted the text into the certificate without any checks to its veracity. What also became apparent in the evidence is that despite Mr. Jones making clear to the LABC that he did not have the relevant expertise to be able to create the K15 certificate, the LABC cajoled him into the role with promises of support that failed to materialise. What conclusions can we draw regarding the certifiers and testers? In essence, the failings of the BBA, BRE and LABC were in part systemic and in part the result of individual negligence and ineptitude. The watchdogs in place, which should have secured the safety of building materials, had been privatised many years ago. And instead, their mission had become warped into acting as the lapdogs of the manufacturers. The evidence tells us at this time there was no independent, no competent certification or testing agency in place whatsoever. The failure by these guardians of public safety stems from the message the individual employees of the BBA, BRE and LABC appear to have taken from their employers, that they worked for a service company. Their aim was to ensure their clients went away happy rather than having any thought of ensuring tests had been conducted in a reasonable or competent manner. There is, of course, a considerable crossover, sir, between Module 2 and Module 6. The dangers of combustible cladding were known around the world and within the UK by the time the lethal materials were placed on the Grenfell Tower. There had been numerous examples of cladding fires demonstrating the real-world dangers to life, such as Garnet Court and Lacanau, amongst many others. Moving forward, we will need to consider the context and culture which allowed these companies to play the system with apparent ease. However, they could not have succeeded in their endeavours unless they were allowed to through the abject failure of regulation and control. The sad and unpleasant truth, which the government has yet to embrace, is that although there is the fault of industry, this does not stand alone, as there was also a gross failure of government to put in place rigorous regulatory requirements in relation to a known and identified risk. The dangers of these materials was well known within government. Individuals such as Brian Martin, latterly of the BRE, and then an advisor to the Ministry of Housing, Communities and Local Government, had been aware of the risk since, at the very least, the Garnet Court fire in 1999. The 2003 second edition of BR 135 was prompted by recommendations following the Garnet Court fire. This iteration contained a now familiar diagram showing the behaviour of cladding under fire, and the authors were Sarah Colwell and Brian Martin. I'm hoping to be able to show the one document I would like to have on the screen, which is BRE 00005554 at page 9. Thank you. This graphic from 2003 displays the likely behaviour of flame in a cladding fire, with the fire climbing a building, entering flats and destroying compartmentation, are foretelling of the fire at Grenfell Tower 14 years later. To the left-hand side of the schematic, it states in writing that I can read, thank you very much, if the external cladding contributes to the flame spread, there is a risk of secondary fire spread to all levels. I repeat that. If the external cladding contributes to the flame spread, there is a risk of secondary fire spread to all levels. It needs repeating that this was in 2003. We can take the graphic now, please, off the screen. That'll be great. Thank you. Mr. Martin had been responsible with Miss Colwell for the drawing up of BR 135 in 2003, was seconded from the BRE to government, taking this knowledge with him. In fact, he was principally responsible for driving changes in relation to external fire safety as part of approved document B, allowing the use of BS 8414 in the revision. This, of course, gave Kingspan the opportunity and foothold within this new market to test their combustible insulation for use in external cladding in high-rise buildings. We should pause to note that it was in March of 2014 that Her Honour Francis Kirkham, CBE, coroner for the inquest for the 2009 Lacanau fire, recommended the following. It is recommended that your department review ADB to ensure that it provides clear guidance in relation to Regulation 8.4 of the Building Regulations, with particular regard to the spread of fire over the external envelope of the building and the circumstances in which attention should be paid to whether proposed work might reduce existing fire protection. These matters were all going on within the time of the Conservative government under the then Prime Minister David Cameron. This was the period known as the bonfire of the regulations, also known as the Red Tape Challenge. This had been promised as part of the Conservative 2010 manifesto. In 2012, the 1 in 2 out rule for regulation was introduced. This was meant to ensure that the cost to business of new regulation was covered by double the amount saved on the removal of others. Later, this extended to an extreme 1 in 3 out. Unsurprisingly, this was suspended after the Grenfell fire. The extent to which the anti-regulatory stance resulted in the failure to grasp the nettle and enforce even the poor levels of regulation existing at the time will be considered in more detail by this inquiry within Module 6. However, we can be clear about this. The corporations in Module 2 acted dishonestly, using a broken regulatory system in pursuit of profit over public safety. What does this all mean? It means that there was clear knowledge of the dangers posed by combustible materials being used on high-rise buildings within the manufacturers, the testing and certification bodies, and the government. However, there is not the slightest suggestion that residents in high-rise blocks, whether they be tenants or leaseholders, knew about the dangers posed by combustible material being placed on their high-rise homes. We should also recall the brave voices of the Grenfell residents, who did express their fears about what they could see of the standards being used within the refurbishment, and who were dismissed as paranoid and ostracized by the authorities that should have protected them. Yet despite the lack of knowledge of the residents and leaseholders, many are trapped living in buildings covered in these materials. Despite their lack of knowledge, leaseholders are still being asked to pay for the remediation costs incurred in the removal of non-compliant cladding. We note the MHCLG have withdrawn from providing oral submissions, but their written closing submissions made to the inquiry make clear they understand and deprecate the role of the manufacturers and the testing certification bodies in the disaster. However, nowhere in the MHCLG submissions is there an apology or the slightest recognition that these regulatory failures and these serious issues occurred on the government's watch. A complacent civil service and the revolving door of ignorant ministers failed to appreciate the risks to life posed by dangerous cladding and failed to introduce any rigor to the regulatory process. We agree the new regulatory structures will be better and more effective, but even now the regulatory changes ignore the fact that residents in social housing and high-rise blocks have views which should be taken into account by the new regulators. Yet industry is still planned to play a part in the new regulatory regime. By contrast, social housing and high-rise housing residents will have a limited voice. Even after all of the deaths and all of the misery, the people who suffer the risk are still being excluded from setting the risk. There are, of course, many issues still to be considered. However, we can all see the evidence which shows there are crooks who operated within the manufacturers, and that at best and being generous, the certifiers and testers were negligent. But Module 2 has also shown that a big part in this tragedy was played by the government, who failed to operate any level of oversight of a poor regulatory regime and actively avoided regulation. Instead, they chose to trust industry. Well, look how that went. It had the effect of turning the crooks into killers, responsible for the deaths of 72 men, women, and children. The people of the Grenfell Tower were not to blame for the horrendously dangerous materials on their building. They are not to blame for their own deaths, and nor are the residents in tower blocks living under this corrosive threat. Nor do the leaseholders living in their valueless flats have any reason to be blamed. Yet they're being asked to pay the price to remove the cladding and make good their buildings. This is wrong. This is plainly wrong, and as morally unacceptable as the criminal actions of the manufacturers, as wrong as the inadequacies and negligence of the testing and certification bodies, and should stop. We see that the changes desperately needed are glacially slow in implementation. We know that there is a very sensible proposal being made to amend the Building Safety Bill to make the polluters pay, adapting schemes already in place regarding contaminated land. We suggest that the government must accept that tenants and leaseholders are not to blame. They should not be made to pay, and they should embrace this proposal and pass it into law. Sadly, to date, all we have seen is a government hell-bent on ignoring responsibility for its own failures, delaying and dragging out remediation, and ruining lives in the process by seeking to make the wrong people pay. The MHCLG has access to the same material we have. They can see the government's failings, and they can see that the government failed to regulate. The MHCLG needs to wake up to its own responsibilities within government, having seen the material that is available on the inquiry's relativity website, which allows us access to the documentations. And they can see that this material identifies the fact that the government needs to radically alter its stance to leaseholders. So those are our submissions on behalf of Team 2 in relation to Module 2.
Well, thank you. Thank you very much, Mr. Steen. Well, you are the last person from whom we are expecting to hear during the course of these closing statements. We're very grateful to you for what you've been saying to us this afternoon. In just a moment, we shall rise, but before we do that, it's probably helpful if I say that the inquiry will not be sitting tomorrow. We shall resume next week, when we shall start with opening statements in relation to Module 5, Module 4 having been deferred until a later stage in the proceedings. So on Monday, as I say, we shall start Module 5 with opening statements from those core participants who wish to make them. Thank you very much. We shall rise at that point and resume at 10 o'clock on Monday next week. Thank you.